Hi, today we're going to talk about the patent timeline and the patent process and how to extend patent protection overseas. So when a client typically comes to us and they want to get patent protection, we normally recommend the filing of an Australian provisional patent application. Now when we hand in the Australian provisional patent application at the patent office, it gets given that day's date as the filing date or priority date. The priority date is important because it signifies the end of the prior art. For a description of what prior art is and how it can affect the patentability of your invention, please see our other video about the patent requirements. Now, when we get that initial filing date for your Australian provisional patent application, that essentially starts a timeline running. And from that earliest filing date, you have 12 months before which you have to complete your patent application. One of the ways that you can complete your application would be, for example, by filing an Australian standard patent application. When you file an Australian standard application, that starts an examination process. In contrast, when you file your Australian provisional patent application, it gets given a filing date, but there's no further processing. Your Australian provisional patent application is also confidential and nobody can see what's in it. The reasoning behind the Australian provisional and complete filing system is that when you file your provisional patent application, there probably would not have been much product development that has happened yet, and the government expects there to be at least 12 months of product development happening. Now, during that first 12 months, while you're developing your product, if you come up with improvements or developments to your invention, then it is possible to file a supplementary Australian provisional application, which provides a filing date for the improvements. And when it comes time to file the complete application, you can combine all of the subject matter together into the one complete. In this way, your improvements and developments during that first 12 months can be captured. So when you file your Australian complete application, this starts an examination process. So your application gets given to an examiner at the patent office. And you can think of the examiner as being the government's gatekeeper. It is their job not to let patents be granted unless the invention meets the requirements for patentability. So when they get to it, at the bottom of their pile, they will carry out a search and they will issue an examination report. And in the examination report, this typically sets out any objections or reservations that they may have to the granting of the patent. Now, once the examination report has been issued, this typically gives us an opportunity to prosecute your patent application, either by arguing why the invention is inventive or amending the claims that we're claiming for your invention to differentiate your invention from the prior art that they've found. Now, hopefully by the end of the prosecution, the examiner is happy with the state of the claims in that it's new and inventive, and they allow it to go to grant. Only once it is granted, that is the first time that you have an actual granted patent. Before it is granted, it's only a patent application and doesn't have patent rights. Only a granted patent has patent rights, that is the right to stop others from commercially exploiting the claimed invention. While it's a patent application, you can put patent pending on your product. When it is granted as a patent, you can put the words patented on your product. While it's a patent application, it does have priority rights, the right to claim priority back to the filing dates of your Australian provisional and your Australian complete. All right, let's talk about how to extend patent protection overseas. So, patent protection can be extended overseas on the basis of two separate multinational treaties that we're going to talk about. The first one is the Paris Convention. Now, under the Paris Convention, it is possible to file complete patent applications directly into the various countries that you want protection in. These overseas complete applications must be done before the 12-month deadline. Now, when you file the overseas applications, we claim priority back to your Australian provisional or provisionals and these countries will recognize those filing dates as if you had filed a provisional patent application in their country. So in this sense, the filing of an Australian provisional will cover you in about 170 countries, which are all the signatories to the Paris Convention, for 12 months. Now, when you go and file the complete applications in the overseas countries, this will start an examination process in each of those countries, very similar to the one described for the Australian complete, and hopefully result in granted patents in each of those countries. Another way of extending patent protection overseas is through the Patent Cooperation Treaty, or PCT. Under the PCT, instead of filing multiple overseas complete applications before the 12-month deadline, you can instead file a single PCT patent application. When you file the PCT application, we also claim priority back to your Australian provisionals, and the filing dates for these provisionals is recognized all the way through. When you file your PCT patent application, this goes into an 18 or 19-month international phase. When you file your PCT patent application, it will enter the international phase, which is 18 or 19 months long, depending on the country, giving you a total of 30 or 31 months from the earliest filing date. When you file your PCT patent application, it automatically results in the carrying out of a search and issuing of a written opinion on the patentability of your invention. You also get the opportunity to prosecute your patent application in light of the prior art that is found in this search and written opinion, and this is for the purpose of strengthening the claims in light of the prior art that was found during the search. However, it's important to understand that even when you prosecute your PCT application, this never ever results in the granting of a PCT application. A PCT application is also sometimes called an international application, and there is no such thing as an international patent, a granted international patent, because there is no process for the grant or the formal grant of a PCT application or international application. So before the end of the international phase, you still have to actually go and file overseas national patent applications into the various countries that you want patent protection in. When you prosecute your patent application during the international phase, this should result in the strengthening of the claims before you go into the various national phase patent applications. Although some people prefer to not prosecute during the international phase and see if any further prior art is found during the national phase. So when you file your national patent applications, your national phase patent applications, this will typically result in an examination and prosecution similar to the one described above for the Paris Convention. The filing of a PCT patent application is typically done where you are not sure which countries you want to file in before the 12-month deadline, and you want to keep your options alive in 152 signatory countries of the PCT. So only by filing a PCT application can you keep your rights alive to file into the PCT country member countries, but this must be done before the 30-month deadline, 30 or 31-month deadline, depending on which countries you are filing in. Another reason for the filing of a PCT application is if you want to file into 3 or more countries, then the actual capital outlay for filing in those countries can be quite expensive. And so if you want to file in 3 or more countries, you would want to delay that capital outlay by filing a PCT application. I hope that the above explanation has been useful for you, but if you still have any questions, please feel free to contact us.